Guys, Assalamualaikum warahmatullahi wabarakatuh. We are from group 9. This is our topic of the impact of the job creation law in environmental law. And next, I will introduce our member of group. First is me, Debby Kemira P.D. Second speaker is Dela Rinanda P, and third speaker is Diva Aisya S. Next. This is our table of content about the law has impact by existence of the job creation. Next. Law number 13 of 2009 concerning protection and management environmental or environmental approval. The public rights of access to participation, information, and justice has been significantly reduced, even to the point of being obsolete. Lose opportunity to practice in compliance and environmental impact assessment is an example. The abolition of environmental permits also has an impact on the potential loss of public access to the zoo. Even more worryingly, the exception to the prohibition on burning for traditional cultivator was also removed. On the other hand, the problem faced so far, such as the concept of forced money in Article 81, have not been resolved. There are still good provisions, but they are a minority compared to those with problem or potential problem. And finally, inaccuracy in the letting will be a problem in the future. Next. And the next slide is law number 41 of 1999 concerning forest as amended by law number 19 of 2004. There have been some substantial change to the forestry law. For example, the provision to maintain a minimum of 30% forest areas based on watershed or island is still removed, even though the faction refused during the discussion meeting. Change in the design and function of forest areas are also no longer based on considering integrated research. In addition, there are exceptions for indigenous people who use forests in forest area as long as they have done so far for 5 consecutive and are registered in the forest areas management policy. Absolute accountability for business actors whose areas are burned is revived. In the late draft, there are changes to several prohibition and criminal acts that are considered to overlap with law number 18 of 2013. Finally, the provision regarding forestry PPNS will return to their original provision in law number 41 of 1999. The next slide will be delivered by Dela Rinanda P. For Dela Rinanda P, times is yours.
Okay, thank you for the change. I will continue the explanation regarding the law that are affected by the existence of the job creation law, namely law number 18 of 2013 concerning the prevention and eradication of forest destructions. There are two main changes that deserve attention. The first is the provision regarding criminal sanctions, which were originally in the February draft, were changes to the administrative fines, were returned to their original provision in law number 18 of 2013, namely imprisonment and fines. This arrangement is more in line with with the principles and the theory of punishments. The management can be subject to corporal punishment. Theoretically, this provision is inappropriate because it has the potential to violate the management's human right by criminalizing it without going through a proper judicial process. And the second is the existence of administrative sanctions and exceptions for indigenous peoples living in forest areas, which has the potential to criminalize indigenous people if it is not accompanied by accurate data collections and recognition of the rights of indigenous peoples and their forests. Next. And the fourth law that are affected by the existence of the job creation law, namely law number 39 of 2014 concerning plantations. The main next the main note in the plantation sector is for the further regulations of the obligation to have an analysis, environmental analysis impact, risk analysis, and infrastructure for handling forests and land for fires in government regulations. On the one hand, the power of the government regulation is certainly weaker than the law because it cannot provide criminal sanctions if the regulated obligations are not fulfilled. On the other one hand, and assessments of these changes cannot be carried out now because they still have to wait for the government regulation to be issued. Another note is regarding the returns of several articles that were deleted in February draft job creation law, but were eventually reinstated in the job creation law, such as the prohibition on transferring land rights, the obligation to cultivate land for a certain period of time after obtaining a permit, and arrangement regarding the facilitations of community gardens or farms 20%. For the next explanation will be delivered by Diva. For Diva, time is yours.
Okay, Dela, thank you for the opportunity. So I will explain about the law number 26 of 2007 concerning spatial planning. That in general, the change provision in the spatial planning law are more related to relaxation in the procedure for implementing spatial planning. This relaxation is primarily intended to accommodate strategic national policies. Unfortunately, it is not explained what is meant or how the scope of strategic national policies that can affect the implementation of spatial planning is not explained. It is feared that this will reduce the role of spatial planning instrument as an instrument for preventing pollution or environmental damage, as well as instrument ensuring the implementation of sustainable development. So, based on the analysis that we find on problems and potential problems are more than positive finding. Therefore, the conclusion that can be drawn are from the law number 32 of 2009 that the protection and management of the environment, the main problem in this law is reduction of the community right to the access in obtaining the right to a good and healthy environment, be it right to information, the right to participation, and the right to justice. But for eliminating the exception to the prohibition on burning of a traditional cultivator has the potential criminals and transfer the burden of responsibility. And then the law number 41 of 1999 concerning the forestry, the main problem was the abolition of the ministry 13% forest that based on the watersheds or island although the function reviews during the discussion meeting. The designation and function of forest areas also no longer based on but only considering integrated research. In addition, there are exceptions indigenous people who use forest in a forest area. And then the law number 18 of 2013 concerning the prevention and eradication of forest destruction. The main problem in this law lies in the formulation of administrative and criminal sanctions that are not appropriate. So the law number 39 of 2014 concerning the plantation, the main problem lies in the various basic provisions which were previously detailed in the remove and the mandate in the government regulation. So, and then the law number 26 of 2007 concerning the spatial planning in this law, the main problem is the weakening of the position of the spatial planning as an instrument for preventing pollution or environmental damage. And these 5 conclusions indicate in the job creation law it is the impact of the job creation law in environmental law can be weakened the environmental protection instrument, community rights, and also has the potential to have a negative impact environment equality. So that's all from us. Thank you for all attention. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.